Okay, thank you to everybody who's joining us for our webinar today. The topic that we'll be covering is new reporting obligations under the Corporate Transparency Act, what healthcare providers need to know. The presenter today will be Timothy Crisp. He's a partner with Holland and Hart. We will be answering questions at the end of the program, so if you have any, please drop them into the chat feature in WebEx, and we'll address them at the end of the program. So Tim, whenever you're ready, please feel free to take it away.
Thank you, Rachel, and welcome everyone. Thanks for joining us, depending on where you are. Good morning or good afternoon. We'll get started. Rachel, if you could flip to the first slide, please. Okay, just a quick disclaimer, which I think should be patently obvious, but we got to say it anyway, which is this is an educational and informational webinar. We hope that you find it of value, but we're not giving legal advice for any specific situation, and we're not acting as your attorneys here. Next slide, please. I'm going to start by giving a little bit of background because as you'll quickly learn, if you're subject to the Corporate Transparency Act, you're going to have some pretty significant burdens potentially. And I think it's important to understand kind of how we got here, why this is unlikely to improve or get repealed, and it's kind of our new reality. The Corporate Transparency Act, or what I'll refer to as the CTA, was passed at the beginning of 2021, New Year's Day. There were attempts by Congress to pass a similar law for several decades, dating back to the early 2000s. And it was finally passed by attaching it to funding legislation for 2021 funding our armed forces in a Defense Department reauthorization bill. Kind of a weird quirk of Congress is that the House, which has to initiate funding bills, can't attach non-germane, that is, legislation or provisions that are not relevant to funding the Defense Department, but the Senate can. And so the Senate added this as an amendment along with some other things, and it ultimately passed with only a few dissenting votes in Congress. Overwhelming bipartisan support, which is almost unheard of. Perhaps surprisingly, then President Trump, who was soon to leave office, vetoed the act, but Congress then overrode his veto, and that was, just as a trivia thing, the only time that a Trump veto was overridden by Congress. Next slide, please. So the regulatory agency tasked by Congress to oversee and create rules and implement and enforce the CTA is the Federal Financial Crimes Enforcement Network, or what is known as FinCEN. It is a branch of the Treasury Department and is kind of the FBI or similar kind of intelligence and enforcement authority for financial crimes, including money laundering. FinCEN issued rules to implement the reporting requirements under the CTA a couple of years ago, and they became effective January 1 of this year. So they are live, they are the law as of the beginning of this year. There are several other rulemakings which are in process relating to how financial institutions like banks and credit unions can access that information as well as others. And relating to database security, among other things, but the requirements that apply to healthcare providers are already in place. Next slide, please. So why we have the CTA is there's been a concern for a long time in the federal government and internationally that law enforcement and intelligence communities lack the critical information and tools that they need to identify and pursue criminal activity and go after the wrongdoers. There is an international task force that was created several decades ago that basically rates and grades each country in terms of their anti-money laundering and countering the financing of terrorism regimes. And for many years, it gave the U.S. a failing grade because it did not have a CTA-like act, unlike most of the developed world, such as in Europe and Australia and many other countries. So this is nothing new if you've been in or had companies in Europe or Australia or other places. They've been requiring this type of reporting for a very long time. Next slide, please. So one of the earliest efforts to pass a CTA-like bill, then Senator Barack Obama was a sponsor. So those of us who remember when he was a senator, he and others tried to establish a regime in the U.S. that would require beneficial ownership reporting by private companies. It basically kept being reintroduced in each Congress and not really going anywhere. But then something that happened offshore, namely in Panama City, created an opening and an opportunity and created the impetus that was needed for Congress to get together and get behind a bill. And that was called the Panama Papers scandal. Basically, documents leaked from a Panamanian law firm, Mossack Fonseca, in 2016 showed that there was a tremendous amount of use that this firm was involved in, using and setting up shell companies from wealthy elites and oligarchs around the world to hide assets, avoid taxes, engage in money laundering, narco trafficking, human trafficking, financing terrorism, and other types of things. So this data breach, and the government, our government tries to prevent data breaches, but this one was one that they welcomed because it kind of opened the curtain and they could see what was really going on by use of shell companies. Next slide. And here's a quick graphic that I found that kind of details the sheer amount of what one law firm's leak revealed in terms of what was going on with shell companies, most of which apparently were set up for nefarious purposes. Next slide. What that did was it created some questioning within the U.S. about, hey, what's really going on here, and are there shell companies that are there companies, I guess I should say, that are being set up that we don't have the information on, and there's not adequate transparency. They're sufficiently opaque that we really have no idea who's behind them, and these companies could be, again, used for bad purposes. And among others, the New York Times at the time, in the wake of the Mossack Fonseca data leak, did an editorial pointing out that Delaware, Wyoming, and Nevada, and in fact, they only picked out 3 out of 51, including DC, states were allowed companies to be set up without reporting of ownership information and who was really behind it. The reality is virtually every state and every type of entity did not have this type of information that the CTA would require and that Congress would soon be mandating. Next slide, please. So after Panama Papers, suddenly Congress got their stuff in gear and quickly worked on a bipartisan basis to say the U.S. is getting a bad reputation because we don't require this, we can't pursue this. Law enforcement and intelligence communities, including the Treasury Department, quickly got behind a concerted push to get Congress to put something together so that we can avoid this type of thing in the future. And Congress made findings that our failure to date to mandate the reporting and collection of beneficial ownership information of entities was a vulnerability in our anti-money laundering efforts and our efforts to counter the financing of terrorism. And it created opportunities for criminal groups and actors to hide behind an entity and engage in bad conduct. Next slide. So after the CTA passed and FinCEN started proposing rules, it noted in its rulemaking that it had found that, among other things, Russia and Russian oligarchs, after the war in Ukraine started, were using U.S. and foreign shell companies to evade sanctions. And one of these was tied to a huge super yacht owned by a Russian oligarch. That once they were able to crack that, figure out that this guy, Viktor Vekselberg, owned this yacht, it was seized in, I believe, Spain, and due to alleged violations of bank fraud, money laundering, and sanctions regimes. Next slide. Closer to home, FinCEN found that the PPP, or Paycheck Protection Program loans that were COVID relief for businesses that many of you may know about, that program was being defrauded by companies that were set up and where there was no transparency in terms of who was making false representations to get the loan. Next slide. Until the CTA was enacted and the registration of beneficial ownership opened up earlier this year, there was never any federal registry of businesses and their beneficial owners. And states have never required registration of beneficial owners, and in many cases, the direct owners. When I say beneficial owners, I'm talking about who actually owns an interest in a company, whether it's stock or shares or a membership interest in an LLC or a partnership interest. And by beneficial, they may own it through a company that is an intermediary holder, one or more companies, but ultimately, who's really controlling this behind all those different layers of companies? So I should note, too, that a few states have now enacted or are trying to enact their own versions of the CTA requiring registration with the state. That remains kind of an open thing. New York has enacted it and now delayed implementation. California and Massachusetts, among several other states, are pushing to enact similar types of laws. Next slide. The status quo in many states and the District of Columbia, Puerto Rico, and other U.S. territories is that the organizational papers that are filed by an entity, whether it's a corporation, an LLC, or other type of organization, including, I should mention, as we're talking with healthcare providers here, professional corporations or PCs or professional limited liability companies or PLLCs, they never required listing of direct or beneficial owners, the directors or officers. In other words, who is really controlling and having say-so of how this company is being used. Next slide. What the CTA does is, for the first time, it requires reporting of what we'll call beneficial ownership information, and it's broader than it sounds. We'll get into more detail on that later. For corporations, limited liability companies, professional corporations, professional limited liability companies, and other similar types of entities. And it creates, for the first time, a massive federal database of beneficial ownership information that is the public can't access, you or I can't access, but it's available to domestic law enforcement, national security, intelligence officials, some courts, and certain other authorities. And it's intended to bring the U.S. into compliance with international anti-money laundering and countering financing of terrorism standards like those that are already in place in Europe. By the way, I should mention that just within the past couple of weeks, that international organization just regraded the U.S. and it was improved, although still far from perfect, even after the enactment of the CTA and implementation of this beneficial ownership reporting. So expect that Congress and FinCEN will continue to try to tighten the screws and require more information rather than this being alleviated. Next slide. The CTA applies to most smaller and newly formed U.S. businesses and foreign businesses that are registered to do business in a state. this is the last time I'm going to mention foreign businesses, because I think that most of you are domestic, if not all of you, are domestic businesses, but these requirements apply if you're a foreign business that's doing business in the U.S. as well. If it applies to you, you have to report, and you have to update that report to correct changes and provide sensitive personal identifying information about who the beneficial owners are. That is, who owns directly or indirectly 25% or more of each company, who the senior officers are, possibly the directors or managers of a company, other parties that have significant control by contract, the organizational documents of the company or under law, and so-called company applicants, which we'll talk about in just a minute. Next slide, please. The reporting requirements start for entities formed before this year. They have to file the initial report by January 1 of next year. That is a hard deadline. So if your organization was incorporated or organized or chartered before this year, you've got a year to get your information together and file your initial report with FinCEN. For entities that were formed on or after January 1 of this year, the reporting obligation starts right away. And the first report is due within, it's actually 90 days if you're formed in 2024. If you're formed in 2025 or after, it's 30 days following formation. And the formation is the actual receipt of notice of effectiveness through you're receiving notice that the state has accepted the filing and it's active, or through an online registry. Next slide. As I mentioned, most smaller corporations, LLCs, PCs, PLLCs, and other businesses that are formed by the filing of articles or certificates of incorporation or organization or formation with the Secretary of State or similar office of a state, U.S. territory, or registered Indian tribe are the entities that are subject to it. There is an open question as to whether limited partnerships or limited liability partnerships are going to be covered by this. And in comments in the rulemaking, FinCEN has said, we're not going to give guidance on that. That may depend on what the particular state law under which those entities are organized say, but definitely corporations and LLCs, including PCs and PLLCs, those Congress specifically said are subject to reporting. By the way, in terms of limited partnerships and limited liability partnerships and other types of entities, FinCEN has been kind of giving inconsistent advice in terms of whether they are subject to this. And the government is currently polling secretaries of state's offices to try to get information about state laws applicable to, among other things, general and limited partnerships. And so I suspect that that's going to lead to a drive to tighten the rules and make sure that those are captured too. So even if you are currently you don't fall within these parameters for a reporting company, expect that that may change at some point. Next slide. The CTA and FinCEN's rules did exempt certain types of entities from the CTA's reporting requirements, but only if and only for so long as they continue to meet that or some other exemption requirement. If you're currently exempt and you cease to meet all the requirements for that or another exemption, you have to start reporting within 30 days of your ceasing to be exempt. If you are a reporting company and you later become exempt, you can cease reporting and you no longer have to provide updates. Again, only so long as you continue to be exempt in some way, shape, or form. Next slide. There are different types of exempt entities. One of them that may apply to many healthcare providers is the large business exemption and wholly owned or wholly controlled subsidiaries of those large businesses. And you have to meet all of these three requirements. First, you have to employ more than 20 full-time employees within the United States. Second, you have to have an operating presence at a physical office in the United States. And third, you will have had to have filed a federal income tax return or information return in the U.S. with the IRS for the previous tax year, showing that you had more than $5 million in gross receipts or sales, net of returns or allowances, excluding gross receipts or sales from non-U.S. sources. So the first two, you probably have a handle on. The third one, you may need to check your tax return and see and consult with your accountant possibly to confirm whether or not you meet that third leg of the three-legged stool to qualify for this exemption. The third one is also poses a problem because newly formed entities won't have filed a return with the IRS until the next year, and so they won't be able to meet that requirement during their first year of existence. Next slide. Certain exempt inactive entities will also be exempt under a separate exemption, but the requirements for this are very stringent. The entity had to have been in existence on or before January 1, 2020, so any entity formed after that, you're automatically ineligible for this exemption. You can't be engaged in any active business. You can't have any amount of direct or indirect ownership by a non-U.S. person. There can't have been any change in ownership in the preceding 12-month period, and you can't have sent or received more than $1,000 in funds directly or indirectly in the preceding 12-month period. And lastly, sixth, you can't hold any type of assets, including equity or intangible assets, anywhere in the world. Each of these 6 requirements has to be met or you won't qualify for the exemption. Next slide. There are many other exemptions. I think there are 21 or 23 or something in total, and I've consolidated most of them here. Publicly traded companies, that is those that are registered and reporting with the Securities and Exchange Commission or the Commodity Futures Trading Commission, are exempt because FinCEN's determined you're already providing enough government or information to those governmental agencies, and we can get what we need. Financial institutions, insurance companies, registered money transmitters, certain regulated public utilities are also exempt. And here's an important one. Certain tax-exempt entities are exempt from reporting under the CTA. And this will be important for a number of healthcare providers, notably nonprofit hospitals. A couple requirements have to apply here. First of all, you have to be currently a 501c3 organization and have received your determination letter from the IRS that you are in fact a tax-exempt entity under Section 501c3. If you set the entity up and you have not yet received that determination letter, or if that determination letter is later revoked or suspended, congratulations, you get to start reporting until such time as you get and have a determination letter from the IRS that you are in fact tax exempt under Section 501c3. Finally, wholly owned and or wholly controlled subsidiaries of certain categories of exempt entities, including the large companies and including the tax exempt entities, will also be non-reporting companies and don't have to report under the CTA. Next slide, please. So for entities formed before January 1 of this year, you get a year or until January 1 of 2025 to file your initial report. For entities formed this year, you have to file your initial report within 90 days of the date of incorporation, or formation. Finally, for entities formed after this year, that 90-day window drops down to 30 days. And so that's a pretty quick period of time from when you file with the state until you have to do your first filing with FinCEN. Next slide, please. If you are not exempt and you are a reporting company, you have to report the following types of information to FinCEN about the reporting company. The full legal entity name, that is what appears on the articles of incorporation or organization, any trade name or doing business as name that is used by the entity, the physical street address of the entity, and the taxpayer identification number or EIN for the entity. Next slide, please. For any individual who is a company applicant, and by company applicant, I'm talking about the following people. First, the real person, that is somebody with a beating heart, not a service company or a law firm that files it. The person who actually submits the piece of paper or clicks to submit the form of the Articles of Incorporation with the state that organizes the entity, that person, as well as anybody who directs the filing or controls the filing. The report requires no more than 2, so it is definitely the person who actually submits it to the state and whoever is the person who is most in charge of directing the filing. That is, so if you're one of those people, you are a company applicant and you have to provide the following information. You have to provide your full legal name, your date of birth, your complete current address, a copy of your current unexpired passport, driver's license, or similar ID, or if you already provide all that information separately to FinCEN, if the person does, they can get a FinCEN identifier number, which is kind of like a known traveler number that you can just plug that in and provide that for any company that you're a company applicant for or otherwise have to report to FinCEN, because FinCEN already has all this information on that person. Next slide. And you basically have to provide the same information for each beneficial owner of the reporting company as you do for a company applicant. Full legal name, date of birth, complete current street address, physical street address, not a P.O. box, and a copy of your current passport, driver's license, or a FinCEN ID number in lieu of all the foregoing. Next slide, please. So we haven't really covered all the people who could be a beneficial owner, and it's much broader than it sounds like. You don't have to own or have the right to acquire or indirectly own any equity before FinCEN and the CTA consider you a beneficial owner and subject to reporting. So you are a beneficial owner in one of several ways. Any individual that, again, is a real live person, not an entity, who has a direct or indirect ownership or control of at least 25% of the ownerships of the reporting company on a fully diluted basis, including non-voting ownership interests. This includes if there are any options or warrants or subscriptions to acquire equity or any debt that's convertible to equity. It assumes all that has been converted to equity. And so that's how you calculate that. This is a fairly easy calculation if you only have individuals who are equity holders and there's only one class of equity. It gets very complicated if you have your equity that is owned by entities and you have to go upstream and get information from those entities about who the real live people are who may own that threshold amount. It also gets complicated if you have different classes or series of equity, such as classes with different voting rights or no voting rights, things like that. And so if you have a situation like that, you will likely need to consult with one of several resources, your accounting firm or an attorney who regularly handles CTA advising should be able to help you to make the right calculation and make the right certification. Secondly, any individual who exercises or has the right or ability to exercise, whether they do or not, substantial control over the reporting company is a beneficial owner, regardless of whether they directly or indirectly have any ownership interest in the company or a right to receive it. That includes all senior officers, probably directors and managers of limited liability companies. Next slide. As we talked about, the FinCEN identifier number is one way of not having to provide all this information about an individual more than once. And the individual, not the company, will have to go separately to FinCEN's website and provide the information and obtain one. It's a fairly easy process. I did it shortly after FinCEN opened the portal and made these available. And it took me less than 10 minutes from when I got to the site to getting a FinCEN identifier number out there. Next slide. A report has to be updated or corrected if any information that you report to FinCEN is incorrect or it changes such that it becomes incorrect or incomplete. And anytime any of those things happen, you have to file the correction or update report within 30 days of the change. So examples of these include a change in the entity name. You file articles of amendment and you make even a minor change. You got to keep in mind that you will also have to report that change to FinCEN within 30 days. A change or addition of a new trade name or a DBA name, or that you stop using one that you previously reported to FinCEN. You have to report all that change to FinCEN. If this is an owned entity and not a nonprofit, any transfers or gifting of direct or indirect ownerships that might lead to somebody holding 25% or more or ceasing to hold 25% or more, you have to report that change. Changes in senior management or the board, issuance of new stock or membership interests, debt that's convertible into equity, warrants, options, or subscriptions, that could change the calculation of who owns 25% on a fully diluted basis, and the redemption or cancellation of equity, convertible debt, or warrants or options or subscriptions. Next slide, please. It's important to get this information and to keep on top of changes and to make sure it is right and to make changes promptly, because the person who submits a report, that is, clicks the button on the FinCEN website and reports on behalf of a reporting company, makes a legal certification to FinCEN that the report is accurate and complete. This is not subject to, whatever you know or whatever you found or things that are material. So there could very well be things that you don't know and that aren't material, but you're making a blanket statement to FinCEN, this is accurate and complete, full stop. Any person who willfully provides or attempts to provide false or fraudulent information to FinCEN, or who fails to report complete or updated information, or causes the failure, or is a senior officer of the entity at the time of the failure, is subject to civil and criminal penalties. So if you are a senior officer, and I'm talking here about a president, a CEO, a COO, a CFO, general counsel, or anybody holding similar types of positions regardless of the title, you are responsible for making sure that this report that is submitted by whomever within your organization or whatever third party is correct, complete, and there's no willful provision of false or fraudulent information, or you could actually face civil or criminal penalties, even if you were not involved in the preparing or the submission of the report to FinCEN. Anybody who provides or attempts to provide beneficial ownership information to FinCEN, directly or indirectly, a person provides or attempts to provide it, if they do so directly or indirectly, including by providing information to another person for purposes of a report or application. So if you are directly or indirectly providing information that's included in the report, you have a responsibility to make sure that information is correct and complete. Next slide, please. So once the person clicks submit and FinCEN receives it, it goes into a massive new database to house all the reported information from about all the companies, all the beneficial owners, and all the company applicants. The data has to be held for at least 5 years beyond the date on which the reporting company terminates. And that could be later than the date that a company ceases business or dissolves. It's basically when the company is fully wound up, its assets and liabilities are fully dealt with, and there is no ongoing business. As we talked about, the CTA limits access to that reported information to national security agencies, intelligence agencies, federal law enforcement, state or tribal law enforcement if they get a court order, federal banking and securities and commodity regulators. Under certain circumstances, foreign law enforcement agencies and intelligence agencies can get access to the information. And lastly, if a bank or credit union customer gives its consent for your financial institution to get the information from FinCEN, the financial institution can request it and obtain that information as part of their customer due diligence requirement. For those of you who have been involved in setting up any kind of banking relationship, whether it is a deposit account, a trust account, treasury management, a loan account, whatever it might be for your healthcare provider, you've had to provide much of the same kind of information we've been talking about in the past to your financial institution as part of their customer due diligence requirement. Going forward, at some point, banks are going to be able to likely stop receiving that directly from the customers and will be able to access that from FinCEN. That portal has not yet been open, and that's one of the rulemakings that still remains in process and is not yet finalized. Next slide, please. So it's important, and hopefully you all have been paying attention and this has been informative, but it's important to make sure that our entities keep track of this compliance obligation, file and correct and update their reports promptly within the timeframes, and certainly make sure that there's no misleading or incorrect, false information that is provided to FinCEN. There could be civil penalties assessed of up to $500 per day. In cases of willful and knowing violations of the CTA, there could be fines of up to $10,000 or 2 years imprisonment or both. And then for folks who have reports on other companies and mishandle those, I'm thinking here primarily of financial institutions and government officials who obtain access to this. If they use it in an unauthorized way or disclose it, there are other penalties for them. We are told that this database that FinCEN has set up has one of the highest security levels in the federal government. That being said, data breaches are possible, and we read about in the papers many private companies and public companies that have data breaches that are quite embarrassing and create problems for the individuals whose information is inadvertently released, as well as for those companies. There was a major federal agency, the Consumer Financial Protection Bureau, that had a huge data breach, and so even the government is capable of data breaches. So we hope this won't happen with FinCEN. They're saying they're confident in their security. I hope they're right, but be aware of that. Next slide. Some of you may have read about some legal challenges, some of which are still pending and haven't really gotten anywhere. But within the last month, the first case actually resulted in a court ruling, and it was a federal district court in Alabama that ruled that the CTA, as written, was unconstitutional on a variety of bases. The case was National Small Business Association versus Janet Yellen in her capacity as the Secretary of the Treasury. The Treasury Department and FinCEN and the Department of Justice have indicated they will be appealing that decision to the Federal Circuit Court of Appeals that covers Alabama. Personally, I am confident that they will, I guess to say, I am very doubtful that this ruling will stand. I think that either the 11th Circuit Court of Appeals or the Supreme Court will reverse that, or even if the ruling stands and is precedent, basically the court order set out what Congress needed to do, set out a roadmap of what it needs to do to make it constitutional, and it will be a pretty easy and quick fix under a bipartisan Congress to get those changes made. I should note, too, that this ruling only applies to the plaintiffs, that is, the National Small Business Association, and there was one individual plaintiff, and so it is not a nationwide effective ruling. So if you are required to report and you are not the NSBA or that one person, you still have to report. Next slide, please. So here's what you can do now and should do now. Analyze whether your company and any of your subsidiaries are exempt. Obtain and understand and update your company's organizational chart and your register of your equity holders and holders of your convertible debt, options, warrants, and subscriptions to acquire equity. Understand which officers, directors, managers, or others exercise control over the company and are beneficial owners, even if they are not equity holders currently. Amend your organizational documents or enter into agreements with your equity holders so that you can get and update information on who is and who may become or cease to be a beneficial owner. Provide beneficial owners and company applicants with the opportunity to apply for and provide FinCEN identifier numbers rather than having to provide all this information, personal information, to the company, which then has to gather and report it to FinCEN. And lastly, keep track of your filing deadlines. If your company, again, was formed before this year, you have until January 1 of next year to file your initial report, and so you have time to gather your information. But if you formed a new company this year, you have only 90 days from the date of formation to file your initial report, and starting next year, it drops down to 30. Next slide, please. Okay, that's the end of the prepared presentation. Welcome to entertain any questions that have been put in the chat module. Rachel, do we have any questions?
So far, it's just been about whether or not we're going to send the slides after, and one person's having some technical issues. But as far as the legal issues, it sounds like you provided a very nice comprehensive overview.
Great. Well, if anyone has any questions that they think of afterwards, please feel free to reach out to me. My email address is tscrisp@hollandhart, that's HOLLANDHART.com, and happy to help. Thank you all for attending and have a great day.